and you're very welcome to the vacation sittings of the Fifth Court, where we're teaming up with our sister podcast, That Great Business Show, presented by the great Conall O Morain, who also doubles as producer for our legal podcast, Mark.
That's right, yeah, he keeps us on the straight and narrow and makes sure we produce material almost every week, except obviously during these vacation sittings.
Yeah, so regular listeners will realise that while the Fifth Court is on holidays, we've been bringing some interviews that we thought were related, to legal themes that were done with our colleague Conall O Morain on That Great Business Show. And tonight is my turn, Mark.
Yeah.
And I joined Conall very recently, actually, to talk about mediation, which obviously I'm a big fan of. And I tried to set out my views and why I think
and
mediation...
are a mediator, I think?
I am a mediator, yes, and very proud to call myself a mediator. And I got a great opportunity to discuss the value I think mediation brings to resolving disputes and why I think it's the future. So I hope people enjoy this interview.
Silence in the Fifth Court.
It is my great pleasure to welcome back to That Great Business Show one half of the two-person Fifth Court team, Peter Leonard, barrister and mediator, to talk to me about the rise of mediation in business. As I mentioned earlier, cynical old me just wonders if it's effective both in time and cost, or is it just another way of taking money off businesses? Peter Leonard, welcome back to That Great Business
Thank you,
Show.
Conall. Delighted to be back.
That voice. People pay extra for that. Do you know that?
Well, you're so kind.
Since you were on last, you have become a mediator on top of all your other legal pieces of paper. Why did you choose to do a mediation course and do very well in it as well?
Yeah, no, thank you. Thank you, Conall. Yeah, no, somebody told me mediation is the future, Conall, so I said I better get in there. I'm reminded of The Graduate with Dustin Hoffman all those years ago. Plastics are the future. Wasn't that the line from that movie?
There were many other ones as well.
Okay,
My name is Rizzo, not Ratzo.
No, mediation, I have become a huge
that's
convert.
Midnight Cowboy, sorry.
Midnight Cowboy. Oh, yeah. John Voight. I remember it well. The streets of New York. Oh, my God. I have become a huge convert to mediation. And mediation is still relatively new in the world of dispute resolution. I mean, obviously, it's as old as Christendom. You can go back to the Brehon Laws, you can go back to Julius Caesar, and you can get into court and you can fight your case and you can accuse the other person across the room, and then somebody in the middle, an adjudicator or a judge even, can make a decision, and that is litigation. It can be very expensive and it can be very difficult for the parties because, even though law is generally applied in disputes, and, disputes should follow the legal precedents and should go in accordance with that, you never know how the old ball is going to hop, Conall. And therefore, you're leaving everything to chance and you're leaving it to a judge. And I mean, that's the perfect way to do it. And obviously that's provided by the state. The state pay for the judge and all of that sort of stuff. And if you win, isn't it great? You come out and you high five. But if you lose, and sometimes you lose in circumstances where you didn't expect to lose, or you lose big, much bigger than you thought you were going to. And I have to come out and explain to my clients, heartbroken though I am, but I have to be professional and say, look, you've lost. It didn't work out, etc., etc. I only say that because that is litigation and that is the system that is generally used to resolve disputes. I fall out with you, Conall. We go to a judge, third party decides it, and we argue our case, and we have to prepare our respective cases. So mediation has kind of come into play. Again, it started in the States. Sorry, I'm
going to cut across you there for a second because I want to just put the frighteners on people. Commercial litigation, by its nature, attracts big fees. How much does one day out in the High Court cost?
How long is a piece of
string? You were going to say that. But you're talking
about the expertise of the participants. It's crazy money. It is crazy, crazy money, and it's getting more expensive. And weirdly, people are willing to pay it. I shouldn't really be saying that. I'm saying that against the legal profession. But I mean, it is crazily expensive. If you have, corporate firms on board, you'll have partners, you'll have associates, then you'll have barristers coming into the mix. Then you probably will need experts to advise in relation to the dispute, and that could go on for a couple of days. And there's daily rates, and then there's brief fees and crazy stuff. As you know, Ireland is the centre centre of aviation disputes at the moment, and we heard figures of six-figure sums in brief fees for certain counsel. Now, that's highly unusual. I think you were in Fungarola when that story was breaking, Conall. So I'm just saying it can be crazy. Now, obviously, commercial disputes are, that is a once-off. But, I mean, it is very, very expensive, and mediation is a very, very cost-effective alternative to that, and in my view, can be a much better alternative for many reasons.
Now, I'm going to cut across you again, because you say commercial litigation is they're one-off. But a newspaper wouldn't exist. Business pages in the newspapers would not exist were it not for the constant amount of litigation.
Sorry, you misheard me there, Conall. I was just saying in terms of that crazy aviation type case where the fees are at such a gigantic level. But I mean, commercial disputes happen every day. As we speak, some two parties are falling out, Conall, and thanks be to God for it.
Okay,
there you go.
So now back to your mediation. So therefore, you're telling me it's a bigger, better way of doing it.
and it really, I think mediation is only in its infancy in Ireland. Like a lot of things, Conall, mediation started across the Atlantic with our friends in America, and then it moved to the UK. Now, I trained with CEDR. It's a well-known mediation organisation, the Centre for Effective Dispute Resolution, and it's highly regarded.
They're the posh ones. Go on.
Well, look, whatever. So it was really, really good. And I mean, there is a process and there is a system that you employ, which is very effective at resolving disputes. And only recently I was in London. I was invited over by them to participate in a mediation over there, kind of big commercial mediation. And it was just incredible to see how effective it was. In the course of a day, we had resolved very, very complicated legal issues. Both sides had come in with quite strong positions, and we worked throughout the day, back and forth, all the way, ironing out issues, addressing potential sticking problems, and eventually got to a situation where both sides were willing to agree, and everybody shook hands and went home, and an agreement was signed, and money changed hands, of course it did, but a lot of money was saved on both sides as a result of avoiding expensive litigation.
Am I hearing that the process is kind of psychologically driven? That, make people not be so stuck?
Yeah, well, you see, so effectively for mediation to work, in my view, I mean, often people think mediation is just another form of negotiation. So you go down to the four courts. I'm representing you, Conall. You're in a row with somebody else. I meet with the barrister on the other side. We go and I'll say, look, I want 100,000. They say, we'll give you 20,000. And then we meet in the middle and we agree for 50,000 or 60,000 or whatever it is. And that's a form of kind of horse trading, really. I mean, it can be a little bit more sophisticated than that, but that's effectively what it is. Mediation is very different. So effectively what you do is you have two parties who are coming to this in a voluntary capacity. Now, that's very, very important. They want to be there because they're looking for a solution. Okay.
Is that driven by cash? Is that money driven as in, geez, I'm not going to spend 100,000 quid?
Yes, it can be, but there can be other factors involved. Remember, it is private, Conall. That's huge. Okay, you go into court, you'll have, the gentlemen and ladies of the press with their notebooks down the back taking a note of this, and it can appear in the Irish Times the next day. People don't like that. So mediation is done in private. But the wonderful thing about it is if you can gain the trust of the mediator and the skill of the mediator is all important. Not everybody is a good mediator, and not every good litigator is a good mediator. I think that's a fair comment to make. So on the basis of the skill of the mediator, you put, you gain the trust of the parties. You go from one room to the next. Both parties, it's not that they think you're on their side, but you create confidence so that they're open to possibilities, they're willing to discuss, they'll set out positions. The fundamental principle of mediation is confidentiality. Confidentiality.
Okay.
So I'm in a room with you, Conall, and I say, look, this is it. So let's talk about it. Is there anything you want to say? And yourself, people are kind of cagey by nature, especially if there's Bugs Bunny involved. They don't want to show their hand. They don't want to show their hand.
My learned friend, Mr. Leonard, is referring to money when he says Bugs Bunny.
So I mean, it's all about trying to gain the confidence of people, and that's very important. And the personality of the mediator is important. And also, Conall, just to use my other line, you have to be Kenny Rogers. You got to know when to hold them, and you got to know when to
fold them.
Yes. So it's very important. But you have to be able to judge the room.
Are you, as a mediator, on one side or the other?
No.
So I'm in dispute with Jack Smith. So I say I want to go and resolve this through mediation. Do I then go and ring Peter Leonard and say, would you do mediation? Or do I ring up Peter Leonard and say, I'm looking for a mediator. where do I go?
What generally happens in commercial disputes, for example, or any dispute. I mean, employment disputes are always very good for mediation. Construction disputes, really good. Mediation really works in those situations. And, situations like that, family disputes over wills, probate, ideal for mediation. And mediation can address issues like, for example, if it's a probate dispute, it's family fallout over a will. I mean, that's as old, that goes back to old God's time. And it's very, very sad. But a mediator, a skilled mediator who has a bit of empathy and who can engage with somebody can go between the two parties, and they can create the atmosphere which will lead to a solution in private. Remember, things to do with family, privacy is so important.
But who has hired you? Is it, do both sides say, we want Peter Leonard? Or does Jack Smith say, Peter Leonard is my man, and I say, oh no, Mark Tottenham is my pal? Okay,
very good question. Okay, so what would happen is, the representatives of Party A say to Party B, what about mediation? And they say, okay, we agree to that. So Party A will say, look, we're going to recommend 3 mediators, and you come back and see if you're happy with any one of those and select one. And then we'll contact that individual and see if that individual is available. It's as simple as that. But it's very important that you get the right mediator. Now, obviously, Conall, I'm working in this field, so I think I'm wonderful. But I'm just saying it is important that people sometimes people are recommended. I think, there are mediators for certain circumstances. So then once the mediator is appointed, the mediation commences. Okay, so initial contacts, that's all part of the mediation. It feeds into the mediation. So generally what I would do in that situation is I'd contact both parties and I'd ask both parties to prepare a brief submission, not a crazy legal submission like you get in the High Court, but something which sets out the points that are important to them. And that allows the parties to focus on what is important, if you know what I mean. A short, brief summary is always better than a big, lengthy, where you throw in everything, including the kitchen sink.
But people want to do that because they hate each other at that time.
So, I'm trying to control it at this stage. Now, remember, it's all voluntary, and people only engage when they're happy to engage. That's very, very important, okay? But in terms of the 2 opening submissions, and you exchange those, then I would have a brief Zoom interaction with either of the parties, get to know them, find out who has authority. That's always very important. You don't want to go into a room where nobody has authority. You want somebody who can make a decision. That's important to establish that right at the start.
And what do you ask? Have you the power to say yes or no?
You engage with people, but you do it in a very informal way. Conall. So I'm sitting down with you and your lawyers and I'm saying, okay, I've seen what this is about.
No wigs and cloaks.
No wigs and cloaks. No, none of that. None of that. And it's not litigation. The mediator there is to facilitate. But it's not a case, there's lots of mediation out there and, official mediation, and people just kind of turn up and say, well, John is looking for the car, and Mary says, no, well, I want the house. And, they're saying the car. They're saying that. There's no value in any of that. What you need is to understand what the issues are. No case has a counsel of perfection, Conall. There are always going to be infirmities. There are always going to be weaknesses. There will always be vulnerabilities. Take, for example, inheriting a family house. For example, maybe it's ironclad in the sense that the will seems to be unimpeachable. But, there's an emotional fallout. There's something there. They don't want unhappiness. So come together and let's work out, a solution to that where both parties can go away. Maybe both go away unhappy, but go away with a compromise and it makes people feel better. So then what happens is you sign up to a mediation agreement where both parties agree to mediate. And they'll obviously have to also, confirm that they're willing to pay the fees of the mediator. And then practical considerations are important. For example, you need, let's say, to go to a hotel, hire a hotel. If it's a solicitor's firm, a major solicitor's firm, they probably may have offices that you can use, which would be more cost effective. But you need a separate room for each party. And then you need a common room that people can come into. Now, every mediation I ever did before I trained with the Cedar crowd in London, we never ever had a plenary session. The 2 parties never came together.
What's a plenary session?
Plenary session would be where you bring both parties into the same room and they kind of face off against each other, but in a very controlled and gentle way. Okay? So normally what happens is, people get their room and they sit in the room and there's tea and coffee in the corner and they stay there till 5 o'clock and then hopefully there's a resolution. And every now and again there's an interaction. But really to make this work, what what you would do is start the process, bring both sides in, nominate an individual on both sides just to open and say what their position is. So it allows the other side to get a flavour of it. Just get a flavour of it at the start. Then you go back to your respective rooms. Mediator will go in, start with one party and say, okay, so look, just let's talk through your case at the moment. So you're saying you want, 500,000 because you did X, Y, and Z. And, the other side, you've heard from them there and they have just said, how do you feel about that? How do you talk about it? And you get into it and you get going and you start working through it. And you remind people that this is entirely confidential. You will not say anything to the other side unless you get specific permission. And it is very, very important that when you're leaving the room, you're saying, are you okay if I say you're making an offer of 20 euros? Are you okay if I tell the other side that? And you want to make sure that they're happy about that. Because remember, mediation, if it doesn't work, it has a great chance of working, Conall. I'm a great believer in it, and I think generally it should work. But if it doesn't work, you still go back to court, and therefore people don't want to give too much away if it's not happening. But then if the dynamic is beginning, in the course of the day, movement occurs, and it is up to the skill of the mediator to work with people, to identify issues that they might be concerned about, again, in a very gentle way, to kind of point out, well, the other side seems to be emphasizing this. What do you think about that? Is that something that you need to consider? How strongly do you feel about that? All these questions you work in and you engage with, and there is a dynamic that develops, but it's very, very important that the mediator has that ability to empathize with the parties and also sometimes to, as I said, fold them and hold them, sometimes pull back a little bit, sometimes say, well, okay, I see you're very strongly committed to that, but I noticed from the other side that they're kind of emphasizing this point. And all the time it is the parties who are deciding to move. A little bit of coaching.
You've gone into therapy.
It's great. It's great.
It's therapy.
Yeah, but it's a commercial decision. It's about, at the end of the day, that's what it's about. It's about deciding. Because, for example, I have been involved in, disputes, let's say, involving building companies and then clients, and they're unhappy about the quality of building, etc. But they've also got a building. They've also got something. And sometimes people say, oh, this is a joke. But it's not a joke. It has to be apportioned. You look at the contract that was originally there. You look at what the commitment was. You look at what has been received. Okay, so maybe it's an only 80% job. So that means you're really only entitled to 20%. But sometimes people have to understand that. You have to work through it. And in working through it, you have a very good chance of getting a solution. Trust me, Conall. How long do these negotiations go on for? Because you mentioned at the end of the day, and I was wondering can you do it in a day? I'm thinking of Roy Keane here, at the end of the day. But yeah, you can do it in a day, and that's better, really. There should be a focal point. There should be, sometimes people need to move, and it's kind of, it's only at the kind of the 11th hour that people can sort of, really sort of focus the mind. Other than that, they can play around with it. But nobody is boxed in. This is the important thing. Nobody's boxed in. And if it doesn't resolve itself at the end of the day, you can continue on and you can keep it open and you can have interactions with the parties. And it may require, somebody to go back to an office and have further discussions, and reflect on things a bit more. And therefore, but even if it doesn't resolve itself, and, the statistics, when it's done properly, Conall, it has to be done properly. The statistics are of a very high success rate, 80% plus, of disputes can be resolved in this way. But even if they're not resolved, they can be very informative and they can sort of establish, the circumstances in which a settlement can be achieved down the line. And a settlement is always your friend in law. You don't want to go into court and come out and have me telling you a sad story as to why the judge found against you.
And you said that just both sides sign an agreement when they are agreed. That, I presume, is legally binding, or is it? Or can I leave you and say, I've signed that? Nah, I didn't like that, and go back into court?
No. Okay, so there's two agreements. There's the agreement at the start, and then hopefully the agreement at the end. And that's a binding contract.
Okay.
Because you enter into terms of settlement of the proceedings. The mediation has been successful. Both parties sign up to an agreement. That agreement is binding, and that agreement can be enforced in court, and it is a binding contract. But the mediation agreement at the start is only that both parties are willing to come together, that the hardworking mediator gets a few bob. I
noticed that's at the beginning.
But it is very, very important that people know they can walk out at any stage.
Okay.
I've had enough, Conall.
And agreements like this have to be presumably registered somewhere.
No, they don't. I mean, it's agreed between the parties.
No,
So,
at the end, when we're both agreed that it's whatever the settlement is, does that not register somewhere?
No, it'll be a contract between the two parties.
And the reason I mentioned that is I was just wondering because you're very keen on the fact that it's confidential, but if it's registered...
No, the terms are confidential, but it can be disclosed to court for the purposes of enforcement. You know, you get an order of specific performance of an existing contract. So, for example, if there's a row, etc., and you agree that under the terms of this, you're going to pay X amount of money, and the recipient of that money is going to give you 10 acres of land, and that's written into a contract, that's a binding contract. You go into court and you can enforce it then.
Okay.
You know?
And presumably your learned friends who love a bit of commercial litigation can't be mad keen about this stuff, is it?
Well,
are you eating their lunch?
It's a bit like, as you are an avid listener to the Fifth Court.
It's a very fine podcast, I believe.
Well, you might recall I had the pleasure of talking to a man called Leif Nissen Ludbeck.
It was a brilliant episode.
Oh, well, thank you, Conall. But he was a fascinating character. And you were talking about AI. And I mean,
as we keep reminding people, not artificial insemination.
No.
Which we would have been talking about 30 years ago.
That's back down on the farm. We're not on the farm for this one. But it's like that has the potential to revolutionize the legal system and also affect that most beloved aspect of solicitors' practices, the billable hour.
Yes.
So, but yet they're embracing it. So they have to embrace it.
And that is now. That's not in the future. That's German companies at CSM or CMS or something.
CMS.
They are using that now for 7,000 solicitors, I think.
Yes, they are. And I mean, but they've moved with the times. Now, I mean, you know, it doesn't mean that lawyers are redundant. They will still be needed. But I mean, tedious work of going through documents and finding stuff can be replaced by AI. I mean, AI is incredible what it can do. I mean, I was in another program I was invited on at one stage after the Dublin riots, when all these guards had to be sent to look through CCTV footage throughout the city in order to try and identify people who are running amok. That could have been done very quickly with AI. So, I mean, manpower will be replaced by AI, and therefore, you know, billable hours have to be replaced by AI. But in terms of mediation, I'm a huge fan. I'm actually a huge fan because I think sometimes litigation is very unsatisfactory. I really do. Whereas I think if you can mediate a settlement, you have to consider all aspects. And it is very important as a mediator. And as a mediator, I would, you know, again, I have to gain people's confidence. So I don't sort of trash anybody's way of thinking. I will go with that. You know, I mean, you don't have to like the parties as such, but you have to understand what they're saying. And you have to understand their concerns. And you have to be able to engage. It is part psychology, but also with the notion of what is in the background, i.e. litigation, and what they're facing if they can't come to an arrangement.
And asking a lawyer like you about money and fees, I know it's just impossible, you'll never give me a straight answer, but typically, is there a massive saving to be made?
There is an absolutely massive saving to be made. Okay, if it is at a certain level, I mean, obviously, let's say there is a kind of a minor dispute whereby somebody goes into, you know, the district court. Well, then the district court judge is, you know, paid by the state to resolve that issue. So, you know, it mightn't be worth your while then to go to mediation. But even if you're getting into the circuit court, if it's going to be a trial, if it's contentious, if it's going to go into a second day, referring it to a mediator. But you see, sometimes litigators get upset about this because, you know, they go into mediation with no belief, don't really want to engage in it. It's a waste of time, and then they have to go in and litigate anyway. And then the client has to pay the fees of mediation on top of this, and everybody's crying a river. Okay? So if you believe that this can be resolved, if you want a resolution, and remember, it's the parties that take control of it, Conall. At the end of the day, you know, you might have to cede something, you might have to trade something, but you're in control of that. You make that offer to the other side. You say, look, I'm going to go down the road with you as far as this, but I need you to come back. You're in control. You're not sitting there looking at a judge telling you what to do, you know? And I think it's really, really important. And it is, I have seen it. It can be very, very successful, but the parties need to engage with it in good faith, but it is down to the mediator. I'm telling you, Conall, it's very important. Get the right mediator.
And it is, as you say, the future. Now, you do know, and if you don't know, it means that you haven't been listening to the show, is that there is a final question we ask everybody, because you have your final question you also ask. We ask people, who would they hire in a heartbeat? Do you remember that question?
I do remember that question. I do remember that question.
I don't know what I'm going to ask you to do. My gorgeous former boss, Micheál Ó Morain.
Yes.
And I was going to say to you, talk to me about Micheál Ó Morain for 2 minutes, because you knew him.
Yes.
And I loved him. He was a magnificent boss.
You had the pleasure of working directly with him. I worked in RTE when he was there.
He was my chair of my first job.
And I ended up in commentary boxes with him and press boxes with him. And he was a wonderfully generous individual, and that is true. You know, people say that about people, but in this case, he had time for everybody. He had a memory that was just incredible. He could remember matches, he could remember individuals, he could remember connections, and he went around the country, and the country was his landscape. He could land at a match in the north, he could land down in his beloved West Kerry, he could go, to Galway, and he'd go in and talk to people. He could go into the inner city of Dublin, and he was able to engage, and that's where he taught all his life in O'Connell School, right in the heart of the inner city of Dublin. He had that just incredible ability to engage with people. He was so quick-witted. I mean, you've seen all the commentary, the commentary statements, and all of that sort of stuff. He was so quick-witted and could come up with a line. And if you threw a question at him, he had that beautiful way, the beautiful kind of Kerry lilt, West Kerry lilt, and the Gaeilge, and the way it would come in. And also Gaeilge. What did he do for Gaeilge? It was amazing. He made Irish so attractive to people, and also he wasn't a purist, Conall. He would switch between the two. I speak both Irish and English, so please don't adjust your set. Remember the old gags. So it was all of that sort of stuff. He was a very, very special individual, and 93 years of age. What a wonderful life! What an absolutely wonderful life, and what a contribution he made to Irish society.
And again, my many, many memories of him was driving around with him, and he started talking about horses. Geez, what he didn't know about horses. And then he started on about the hounds, and I'm looking at him saying, "What do you not know about?" He was an incredible person.
Yes, fantastic. Did you hear the famous interview? I know they all refer to it, but the interview with Prince Edward after the dog won in White City or Walthamstow or wherever it was. I mean, that was it. And no bother. Could talk to anybody and just had that wonderful, just that wonderful way about him.
So maybe you'd like to hire him in a heartbeat.
Well, I would hire him in a heartbeat, but I was thinking, you threw this on me. I wasn't actually expecting this, Conall. It's been about a year since I was in this studio.
I sent you the email, which I sent in everybody, but there you go.
Really? Okay. Oh, very good. Very good. You know who I got to hire in a heartbeat? Please. A fella who's looking for a job. Ciarán Cuff.
Okay.
Ciarán Cuff, sadly, in my opinion, lost his seat in, and I'm not a member of the Green Party, just to say that for the record, but he lost his seat in the Dublin Euro seat in the recent European elections. I think he was a phenomenal MEP. He did so much work at Europe, and you need Irish politicians who can get stuck in and can get things done. And it's not everybody can do that. And he did that. And I think he's a very genuine individual. I think he gave his heart and soul to it. He always told the truth in his way. I'm not saying that nobody else does, but he's a great guy. And I always have a huge amount of fondness for him, Conall, because many, many moons ago, you remember the Gresham, that used to be Sunday lunch for the O Morain family all those years ago, was it?
There is a Gresham Hotel, and I'd say I've been in it twice.
Up the top of O'Connell Street. But there used to be these most amazing trees that were growing there for 200 years, and they were proper trees. And the birds, would nest in the trees and, all this sort of stuff. And in their wisdom, Dublin City Council decided to cut them down. Great idea. And I remember Ciarán Cuff. I think I have a memory. Now, maybe I'm wrong. Maybe it's more a folk memory, but I think I'm right in this. Your listeners can write in if I'm not. But I think Ciarán Cuff chained himself to one of those trees before it was cut down. So I think that is the sign of the man. I would employ him in a heartbeat. No, but really, I think he's a loss to the city of Dublin. I think he's a loss to Ireland. He was a wonderful representative in the European Parliament. Hope he stays in politics, and I hope he continues to make a contribution.
Well, he might be a lobbyist, of course. That is the voice, the lovely, lilting voice of Peter Leonard, who is one half of the Fifth Court podcast.
The Fifth Court will adjourn until next week.
So I hope people enjoyed my discussion with Conall there on mediation and the value of mediation. Thank you, Mark. Did you enjoy it?
Of course I did, yeah.
Okay, you say all the nicest things. Okay, and folks, remember that the Fifth Court will be back in session in October. We'll be back with a whole new series starting in the first week of October. So we hope you'll join us then.